Good morning.
Good morning, sir.
Yes.
One more. Good morning.
Yes.
From supplementary causes under the heading for judgment, serial number 1, MA number 442 of 16, Mr. Alok Lal for the appellant, Mr. Shiva Prasad Sinha, Mr. Anil Kumar for the respondent.
Uh, in view of what has been held above, this appeal stands allowed to the extent that the insurance company can recover the amount of compensation from the owner of the vehicle.
What is statutory amount, Your Lordship?
The statutory amount to be refunded to you.
Offline.
Under the heading for admission, serial number 2, MA number 654 of 16, Mr. Vijay Kumar Sharma, Mr. Amit Kumar for the appellant, Mr. Manish Kumar, Mr. Ramesh Kumar, Mr. DC Ghosh for the respondent.
Yes. What,
Maybe.
yes. Yes, Mr. Ghosh.
Last year,
My lord,
Yes. Yes.
and the case of the contributory negligence, Your Lordship, and the tribunal has considered the income of the 3,000, Your Lordship. Although
So, right to recovery has been given to you, Mr. Ghosh.
yes, right to recovery.
although Your Lordship, income of as per the evidence, Your Lordship, 50,000 per se. It has come in the judgment also, Your Lordship, and the evidence of the witnesses, Your Lordship. And
No. Right to recovery given or not?
No, finding is there. That is in page number running page 19. Running
Yes.
page 19. Last paragraph के ऊपर, the owner cannot play game with the life of the people by allowing the tractor to be driven on road by a driver having no proper driving license. Hence, the owners have committed willful breach of terms and conditions of the insurance policy. Therefore, owner and driver of the tractor OP number 1 and 2 and 3 is me, are liable to pay compensation. Finding is there regarding violation of terms and conditions, but of course, no right of recovery has been given to me in the operative part of the.
It has not been denied also.
My lord,
There is no whisper about the right of recovery.
G, that's. Of course, no appeal. I have not preferred any appeal, but it depends upon the my lord, honorable court. Because this particular funding is not under challenge regarding the violation of terms and conditions.
Yes, this is not under challenge.
My
The
lord.
owner notices have been served upon the owner validly.
G.
Owner is appearing. Owner is appearing. Anyone appearing on behalf of the owner?
And regarding that deduction, 50% deduction towards contributory, my lord, of course, that funding is not based on any concrete evidence or
Yes.
like that. How about that is?
What about the owner of the vehicle?
Regarding the owner of the vehicle, the joint owner of OP number 1 and 2.
Where is
X40. X40. Before the
No.
code will X40.
No, before the code, before this code,
Before this code, my lord.
respondent number 1 and 2.
G.
1 and 2. It appears that the service of notice has been effected on behalf of respondent number 1 and 2. Ramesh Kumar, advocate, undertakes to file wakalatnama on behalf of respondent number 1 and 2, whereas wakalatnama has been filed on behalf of respondent number 3, no on behalf of 4. 4 is the driver. Where is Mr. Ramesh Kumar? We proceed since he has already appeared. If he don't choose to appear, I can't help it. Yes, claimant.
So far, the other grounds is concerned, Your Lordship.
Yes.
Income of the learned tribunal has considered, Your Lordship, the notional income 3,000, Your Lordship. And as per the evidence has came, Your Lordship.
Where is the contributory negligence which has been dealt with?
Lordship, I have sent the judgment to Your Lordship through a mail, Your Lordship, 2014, volume 4, Your Lordship.
2000,
2014 volume, Lordship, 2014 volume 4, SCC, page number 511, 511. And regarding
what is the journal? ACC or SCC?
SCC, Lordship, Supreme Court cases, Your Lordship.
SCC.
I have sent the mail through, Your Lordship.
11.
And regarding the para 9, 10 and 11, Your Lordship. Para 9, 10 and 11, Your Lordship.
Okay. Where is the income discussed?
Income has discussed, Your Lordship, in the
Internal page
all the
12.
businesses.
Internal page?
12.
Internal page.
Running page 18.
Running page 18. Yes.
From middle portion it starts. Therefore,
Shop jointly. Let us see the evidence. What about the earning you have said? Future prospect not granted.
no.
So let us see what is the evidence so far as income is concerned.
Future prospect is not given, Your Lordship. And the number of Lordship.
Let us see what is the evidence so far as income is concerned, Mr. Counsel.
Evidence, Your Lordship, may I read, Your Lordship, the CW1, Your Lordship, wife of the deceased, Your Lordship, Sumitra Devi, Your Lordship.
Yes.
And she is stated, Your Lordship, and para 3, Your Lordship, यह कि मेरे पति गेट ग्रिल बनाने का काम करके लगभग 15,000 रुपये महीना कमाते थे, उसी से हम सभी दावा करता गण का गुजारा होता था, परंतु उनकी मृत्यु के बाद हम लोग अनाथ हो गए. It has come in, Your Lordship, the CW2 also is stated, Your Lordship, and cross examination also she is stated, Your Lordship.
No, the tribunal when that
And the
all
CW
the tribunal has held that all the brothers were working in the grill shop.
Yes,
So it was a family business or what?
yes. There
Lordship,
is no individual income of any of the brothers.
Yes.
That is finding recorded running page
On what
18
on what basis?
on the basis of evidences, because claimant's witness number 3 has admitted in his evidence
Yes.
the business was run jointly by 3 brothers. And the court below has taken into consideration of the said evidence, discussed the same. In para 19, clearly admitted that all the 3 brothers are earning 2 to 4,000 per
हम
month.
तीनों अलग अलग से कोई आमदनी नहीं थी. So if there is a grill gate shop. These 3 were mechanics. That means it's a fabrication unit. So all the 3 brothers were working there. So it can't be said he was earning only 3,000 rupees per month. His share.
Because they have also admitted that the income was not fixed.
Yes.
The evidence can be read, my lord, either of these. As my lord.
Mr. Sharma, you come to cross
Lordship.
examination para 19 of PW3.
yes, Lordship, हम तीनों भाई मिलकर कभी 2,000 तो कभी 4,000 महीना कमाते, कोई निश्चित आमदनी नहीं थी.
So take down. Third, the learned counsel for the appellants, claimants.
Standard compensation भी नहीं दिया गया है. Standard compensation भी नहीं दिया गया है.
Yes. And what is the judgment which you are referring to, paragraph 9, 10, 11? Let's see. (2014) Volume 4 SCC, page 511. Para 9, 10, 11. Take it. Heard the ordinary counsel for the appellant claimants, comma, the insurance company. Full stop. Yes, who is appearing for the owner?
ये लॉर्डशिप इसको सम पर्सनल डिफिकल्टी इसको कल के लिए रख दिया जाए हुजूर.
Sorry. Okay. The
पास हो गया सेकंड हाफ के लिए.
sorry.
Oh, sorry.
The counsel for the owner appears and prays for some time. Full stop. This court refuses to grant any time to the counsel for the owner, as the case was being heard from yesterday and was kept part heard, and the matter spilled over today. Full stop. After conclusion of the argument, counsel for the owner prays for time, which only after conclusion of the argument, the time was prayed for. Stop. Next para. The I'll be granting right to recover from you, Mr. Counsel. The owner. Uh, the counsel for the claimant. This appeal has been filed by the claimant, praying for enhancement of the compensation amounts, which has been awarded by judgment dated so and so, so and so, so and so. Next slide. The learned counsel appearing on behalf of the appellant submits that the monthly income of the deceased has been wrongly calculated and a notional amount has been accepted by the court, which is rupees 3,000 per month. As per him, since there is positive evidence that the deceased and his two brothers were having a grill manufacturing workshop, notional income could not have been, notional income could not have been the basis, could not have been made the basis of calculating the compensation amount. Full stop. He further submits that in terms of the judgment passed by the Honorable Supreme Court in the case of Pranay Shetty and others, future prospect, compensation on account of future prospect has not been granted by the tribunal, which the claimants are entitled to. The contention of the appellant further is that the tribunal, the claimants are entitled to receive compensation under conventional head in terms of the judgment of the Honorable Supreme Court as delivered in the case of Pranay Shetty and others. First up. Lastly, it is submitted that 50% the tribunal has held that there was contributory negligence on the part of the deceased. Thus, 50% of the amount of compensation has to be deducted. It is this case that the tribunal on a notion has held that this, on a wrong notion, has held that this deceased was riding the vehicle, which in fact is not correct. And full stop. He argues that none of the witnesses have come forward to say that at the time of the accident, the deceased was riding the motorcycle. Rather, there is consistent evidence that it was what is the name? Who was driving the motorcycle? It was Mukesh, who was driving the motorcycle?
Mukesh Kumar, CW2.
It was in fact Mukesh Kumar who was driving the motorcycle.
Mukesh Kumar, and the DC was the pillion driver. Pillion rider,
who was driving the motorcycle, and the deceased was a pillion rider. He submits that on presumption. He submits that it is on the presumption and assumption. The tribunal has held that it was the deceased who was riding a motorcycle and thus fastened the contributory negligence, fastened the concept of contributory negligence upon him and deducted 50% of the compensation amount, which is absolutely bad. Next paragraph. The counsel appearing on behalf of the insurance company submits that there is a specific finding given by the tribunal that the offending vehicle was being driven by a driver without a license, without a driving license. Thus, the tribunal, thus, in view of the aforesaid finding, the tribunal should have granted the right to recover the amounts of compensation. He submits that in this appeal also the aforesaid direction can be given, as the finding that there was a violation of the policy has not been challenged by the owner, and the same has attained finality. He submits that in view of the judgment of the Honorable Supreme Court. Yes, Mr. Ghosh, give me pay and recover.
Pay and recover.
Yes.
Just now, I'm giving. I'm giving one.
He submits that in view of the judgment of the Honorable Supreme Court, this direction can be given in this appeal also. Next part. Yes, Mr. Ramesh, what do you have to say?
ये लॉर्ड इसको पास ओवर करने के सेकंड लास्ट एज ए लास्ट दिया जाए
No, the counsel for the owner of the vehicle has got no submission, as every time he's paying for time and not
नहीं
joining.
नहीं एज ए लास्ट चांस हुजूर उसको जो है कि हमारे पास फाइल नहीं है इसलिए हम कह रहे हैं कि उसको लास्ट चांस उसको कर दिया जाए हम उसको कल कर देंगे उसको
This was being argued from yesterday. It was kept parted, and you did not even join when the case was called. This shows
सॉरी लॉर्ड
how seriously you take the cases. I'm sorry.
लास्ट चांस हुजूर उसको
Sorry.
कर दिया जाए
This is not the way. This is not the way. When the court starts dictating judgments, okay. Next paragraph.
My lord, 2004,
तो हम लास्ट
2004
volume 3, SCC
SCC
297,
297
National versus Swansea case.
Swansea judgments. Yes. Okay. Next paragraph. The husband of the claimant number 1, of the appellant number 1, died in a motor accident. First up, it has been pleaded that on 28/5/2012, on Chatra Dhobi Road, the deceased, along with his nephew Mukesh Mistry, was traveling in a Hero Honda motorcycle bearing number JH13 capital A 7953. It is alleged that the offending vehicle, that is a tractor bearing registration number JH01AJ 8882, at the time of the accident, the registration number was not known. Came from the opposite side and dashed against the bike, as a result of which the deceased suffered injuries and died on the spot. First up, it is alleged that the tractor was being driven in a rash and negligent manner. First up. On base of FIR was registered being Chatra Sadar PS case number 95 of 2012 under section 279 and 304 capital A of the Indian Penal Code. Charge sheet was submitted against accused Rohan Gunya, that is the driver of the tractor, under section 279, 337 and 304 capital A of the Indian Penal Code. First up, the claimants claimed compensation, stating that the deceased was earning 15,000 per month from the grill gate workshop and was maintaining the family. First up, it was stated that the offending vehicle, that is the tractor, was duly insured with with the New India Insurance Company Limited. First up. The parties appeared. The insurance company appeared and filed their written statements, taking ornamental pleas. But they had also, no, but me, full stop. They had also taken a plea that the driver of the tractor did not have an authorized and valid license at the time of occurrence. However, they did not deny the fact that the vehicle was duly insured by the insurance company. Full stop. It is pertinent to mention here the owner of the tractor did not appear, and the proceedings were ex parte against him. Full stop. Next paragraph. Continuation. On behalf of the claimants, four witnesses were examined. CW1 is the claimant, that is the wife of the deceased. CW2, Mukesh Kumar, is the nephew who was driving the motorcycle. CW number 3 is the brother of the deceased, and another witness, CW4. Several documents were also exhibited, like FIR, charge sheet, copy of the registration certificate, insurance papers, driving license, insurance certificates, etc., etc. First up, on behalf of the insurance company, one witness was examined, and the investigation report, original investigation report, and the verification certificate of the driving license of the driver of the offending vehicle was also exhibited. Full stop. The tribunal, after considering the evidence, has assessed, has taken the income, has considered the income of the deceased notionally, and thereafter awarded a compensation to the tune of 4,20,000. First off, the tribunal held that there was a contributory negligence on the part of the deceased, as it is the deceased who was driving the motorcycle without any driving license, and thus deducted 50% from the compensation amount. First off, the tribunal held that the insurance company, the offending vehicle was duly insured with New India Assurance Company Limited, but the driver of the tractor had no valid license to drive the tractor at the time of accident. Hence, the owners have committed willful breach of the terms and conditions of the insurance policy. Thus, the owners and driver of the tractor are liable to pay compensation to the extent of their liability. Full stop. Next paragraph. Challenging the fixation of the quantum and also the contributory negligence, the claimants have filed this appeal. Next paragraph. I have heard the counsel for the appellants and the insurance company, and have also gone through the lower court records. First step. The issue which falls for consideration before this court is colon dash number 1. What should be the income of the deceased? Number 2, whether there was any contributory negligence on the part of the deceased, and whether along with it, and whether the finding of the tribunal that it was the deceased who was driving the motorcycle is based on any evidence or not. 1, 4, whether the compensation has been calculated, assessed and calculated in terms of the judgment of the Honorable Supreme Court as delivered in the case of Pranay Shetty and so or not. And 5, whether right to recovery can be granted to the insurance company in view of the findings arrived at by the tribunal. Next paragraph. To decide the first issue, this court finds that there is no documentary evidence on the point of income of the deceased. Full stop. So far as the oral evidence is concerned, I find that the claimant Sumitra Devi in paragraph 3 has stated that the deceased was earning 15,000 rupees per month and was maintaining the family. In cross-examination in paragraph 11, she states that the deceased did not have a passbook of any bank nor any PAN number was allotted to him. She stated that she further states in cross-examination that there was no accounts of income and expenditure of her husband. Now, right like this. She further states that her husband did not maintain any income and expenditure account, and her income was not fixed, rather was fluctuating. In paragraph 12, she states that she is not aware as to how much her husband was earning. Full stop. PW number 2, who is the nephew of the deceased, only states that the deceased was in the job of manufacturing grills and was earning 15,000 per month. PW3, CPW नहीं सब CW लिखेगा. CW3 is one brother of the deceased. He states that the deceased was earning 15,000 per month and was aged about 40 years. In cross-examination, he states that he has a shop of grill gates and the deceased was working with him. He was working in the said shop. He was working in the said shop, first up. He states that all his brothers are working in the said shop, and the income was joint, and there was no separate income from the grill shop of each of the brothers. He states that sometimes they would earn 2000 rupees, sometimes 4000 rupees, but there was no fixed income. PW4 also gave a statement that the deceased was earning 15,000 per month. Full stop. This is the evidence which has been laid by the claimants, laid by the claimants on the point of income of the deceased. Full stop. From this evidence, it is clear that the statement that the deceased was earning 15,000 per month is a vague statement and is not correct also. The brother of the deceased clearly stated that the income from the grill shop was a joint income of all the brothers, and sometimes they were earning 2,000 and sometimes 4,000 rupees. Full stop. Thus, I find that in view of the evidence which has been laid by the claimant, the and also in view of the fact that the deceased was maintaining a family of how much? 5, comma. This court is of the opinion. This court is of the opinion that 5,000 rupees per month should be assessed for computation of the compensation per month, be the income of the deceased for the purpose of assessment of the compensation, for purpose of computing the compensation. First of this is being held because the fact that the deceased was working in a grill shop and is not disputed. It is not a fact that the deceased was unemployed. First up. Thus, I hold that the income of the deceased should be fixed at rupees 5,000 per month. First up. Next paragraph. So far as issue number 2 is concerned, what is the issue number 2? The issue number 2 is of utmost importance. First up, issue number 2 and 3. Issue number 2 and 3 is concerned. Issue number 2 and next cut here. Issue number 2 and 3 is of utmost importance. The tribunal has held that there was a contributory negligence on the part of the deceased as he was driving the motorcycle. Full stop. On this point, it is an admitted fact at the time of death, the deceased was with CW2. Full stop. CW2, in his evidence, Yes, claimants. Mr. Sharma. Mr. Sharma. Mr. Sharma, Vijay Kumar Sharma. Where is he? Mr. Vijay Kumar Sharma.
Lordship.
Where is the evidence that who was driving the motorcycle?
Lordship. 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 Lordship.
Where is the evidence? Where is the evidence that the deceased was not driving the motorcycle?
That is, my
It
lord,
examine the exhibit C, Your Lordship. Exhibit internal page 4, Your Lordship. A screen
Exhibit-
report of the motorcycle JS13A 7953
my lords will find relevant portion, internal page
CW2 is CW2, Your Lordship.
internal page 10, second paragraph. Hence, on this finding that
CW2, Your Lordship. Mukesh
I'm asking what is the evidence? That is the finding of the court. Where is the evidence?
page 10.
No, page 10 of the judgment you are saying.
Yes,
What is
yes.
the evidence? What is the
Oh,
evidence?
evidence. Yes, that.
My Lordship, internal page 10, Your Lordship.
I'm asking you from the
इसमें
judgment.
Lordship, page of the exhibit C में ही आया Lordship. CW2 Mukesh Kumar was riding the bike and the deceased himself was also traveling as a pillion rider without verifying the RC.
What is exhibit C? Screen report.
Exhibit C, Your Lordship, transfer in the name of the Achilles Mystery, Your Lordship.
Who is Akhilesh Mistry? Who is Akhilesh Mistry?
Vehicle, Your Lordship. And so far the evidence, Your
Subsequent
Lordship,
owner whose
CW2,
name was
Your
transferred.
Lordship.
No, but
Achilles Mystery is the Achilles Mystery, Your Lordship, the brother of the CW2, Your Lordship. Brother of the CW2, Your Lordship. Mukesh Mystery, Your Lordship. Achilles Mystery, son of the Sujit Mystery.
where it has been mentioned that it was
CW2 brother, Your Lordship.
no, where it has been mentioned that it is CW2 who was driving the motorcycle? From where are you getting this?
May the Lordship, CW2, Your Lordship, and the internal page 6, Your Lordship. CW2 and CW3 deposition, Your Lordship. CW3 reiterated that in case of the claimant in examination, the chief that stated the occurrence took place due to rash and negligent driving of the tractor so and so. He further stated that the further FIR was lodged against the driver of the management in cross when he stated on the date of the accident, he was driving the motorcycle. And CW3 also stated that, Your Lordship.
Just a minute. Handwritten one. You'll kill him, whatever it is.
On this point, it is admitted that in the time of death, physical severity.
Full stop. In paragraph 14 of the evidence of CW2, he states that he was driving the vehicle. Full stop. Driving the motorcycle. Further, uh, uh, it has also come in evidence that the vehicle belonged to CW2, but full stop. Uh, but from the reports, that is Exhibit C, screen report of the motorcycle, screen report from the transport department, government of Jharkhand, come in respect of the motorcycle. I find that the vehicle belonged to Akhilesh Mistry and son of Suchit Mistry, and the parties admit that Akhilesh Mistry is the brother of CW4, CW2. Full stop. The tribunal has held that there was a contributory negligence on the part of the deceased as he was driving the motorcycle. The tribunal disbelieved the statement of CW2 only on the ground that the accident was a head-on collision which resulted in death of the deceased. Full stop. As per the tribunal, as deceased, full stop, the tribunal also came to the conclusion that since the statement of the claimants, witnesses, to the effect that CW2 was riding the motorcycle cannot be accepted, as because if said CW number 2 was driving the motorcycle, in a head-on collision, his life was saved with some minor injuries. As per the tribunal, in the case of a head-on collision, it is but natural that the rider of the motorcycle will die and the pillion rider will be saved, and thus the tribunal assumed that the deceased was riding the motorcycle since he died, and CW number 2 was the pillion rider since he was saved. Full stop. This assumption of the tribunal is without any basis and is against the evidence which has been led. Full stop. Though the claimant witness, that is the wife of the deceased, in her evidence stated that at the time of leaving the house, the deceased was riding the motorcycle, but admittedly she is not the eyewitness to the occurrence. First up, the eyewitness and the companion of the deceased was CW2, who stated that the motorcycle belonged to them and it was he who was riding the motorcycle. Full stop. In view of this specific uncontroverted evidence, the tribunal could not have assumed that it was deceased who was riding the motorcycle. This finding, which is based nothing but on assumption and surmises, is being beyond the evidence is perverse. Full stop. Since there is categoric evidence that the deceased was the PW number 3 was riding the motorcycle, PW number CW number 2 was riding the motorcycle, comma, this court holds that there was no contributing in negligence on part of the deceased, and this finding arrived at by the tribunal is absolutely erroneous. Further, the Honorable Supreme Court, in the case of Meera Devi versus Himachal Pradesh Road Transport so and so, reported in 2014, Volume 4, ACC 511, at Para 10, has held that there must be a cogent evidence to prove contributory negligence. Full stop. Without any cogent evidence, a contributory negligence cannot be proved. The Honorable Supreme Court further held that in absence of cogent evidence to prove the plea of contributory negligence, the doctrine of common law cannot be applied. Also, it is necessary to quote paragraph 10 here and below. Full stop. In view of what has been held above, I find that there is no cogent evidence to prove the contributory negligence. उसके बाद लिखिएगा 10 I hold, ऊपर वाला से काट दीजिएगा 10 I hold. Full stop. Next para. The third issue, the issue number, Mr. Counsel, when did the accident take place? What is the date of the accident? Mr. Ghosh, what is the date of the accident?
Date of accident is 28/5/12.
Yes.
28/5/12.
Lordship, it has come to Sangri Valley near the Maya Chuya More, Chatra Dobi Road, Lordship.
5/12.
जी 28 मई.
What is the right to recovery? 4. The issue number 4 is in respect of the whether right to recovery can be granted to the insurance company. Full stop. In this case, I find that there is a specific finding of the tribunal in paragraph 9 that the owners of the इसको ऑफ कर लीजिए तभी आपको सुनाई देगा. The owners of the tractor in question has committed willful breach of terms and condition of the insurance policy. The tribunal has also held that at the time of accident, the the driver of the tractor had no valid driving license to drive the tractor. Full stop. This finding has attained finality. Full stop. Further, the tribunal has held that it is the owner and the driver of the tractor who are liable to pay compensation up to the extent of their liability. Full stop. That being so, when the insurance company, that being so, when admittedly the vehicle is insured, being a beneficial legislation, the insurance company has to pay the amount of compensation and recover the same. This is in view of the judgment of the Honorable Supreme Court in the case of National Insurance Company Limited versus Swarn Singh, 2004, Volume 3, SCC, page 297. Thus, in this case also, the insurance company is at liberty to recover the amount of compensation from the owner of the vehicle as per the after following the due process of law. Full stop. Next para. Now, the question is, now the issue is what would be the compensation? Full stop. As held above, the income of the deceased is fixed at rupees 5,000 per month. Full stop. The deceased was aged about
40 years, Your Lordship.
40 years. Thus, the multiplier of 15 is to be applied. Further, since the deceased was a self-employed, in terms of the judgment of Pranay Shetty, he is entitled for an enhancement of 40% on account of future prospect. Full stop. The deceased left behind 5 dependents. Thus, one fourth should be the deduction on account of personal expenses. Full stop. So far as compensation on account of compensation under conventional head is concerned, in terms of the judgment of Pranay Shetty, he is entitled to get rupees 70,000. What is the multiplier? Multiplier 15.
15.
Yes. What is the amount coming to? 10,15,000. On recalculation, the amount of compensation comes to rupees 10,15,000, which the claimants are entitled to receive. So you have paid any amount, Mr. Ghosh?
Yes, Malla, earlier amount already paid. That the amount already paid may be deducted.
This amount of 10 lakh, the full stop. The insurance company has already paid 2,10,000 along with interest. 2,10,000, full stop. The balance amount of 8,05,000 has to be paid by the insurance company along with an interest at the rate of 6% per annum from 16/10/2016, that is the date of the award, till the same is paid. Full stop. The insurance company, as said earlier, the insurance company is free to recover the amount from the owner of the vehicle. Full stop. This appeal thus allowed to the first extent.
Okay.
Lordship, there is recent judgment of the apex court regarding recovery from the owner where there is no valid license. That is 2022 Volume 1 SEC, page 317.
2022 Volume 1
SEC, page 317.
SCC 317.
You consider all the previous laws, Lordship.
इसको भी निकाल कर रखिए. Yes. Thank you, Mr. Agarwal. Along put in this judgment with that National Insurance 2004 वाला के साथ the recovery. Just a minute. I got disconnected. Yes. Next.
From Delhi Corporate, under the heading Order Field Defect, serial number 1, second appeal, 17 of 18, Mr. Jitendra Upadhyay, Mr. Naveen Sahai.
Lordship, three weeks time to remove defect.
Yes.
In this case, if possible, Lordship, the national local
Yes.
Lordship, perhaps coming Lordship, 12th March.
Why National Lok Adalat? I have disposed the matter. Why should the matter go before the National Lok Adalat? It is decided. There's nothing to compromise, compound. Yes.
Some defect were 3 week time to remove defect.
And memo for appeal is also based upon some fact, hence affidavit may be filed.
Defects to be removed within 2-3 weeks.
Obliged.
Obliged.
Serial number 2, second appeal, 72 of 18, Mr. Shankar Agarwal, Ms. Afa Kumari.
3 weeks to remove the defects.
Lordship, 3 weeks time to remove defects, Lordship. Obliged, Lordship.
Serial number 3, second appeal, 90 of 18, Mr. Sajina.
My lord, appearing on behalf of the appellant, my lord, 3 weeks time to remove the defect, my lord.
3 weeks.
Obliged.
Serial number 4, second appeal, 92 of 18, Mr. Vijay Kumar Sinha.
In this case, I am appearing on the behalf of the appellant, my lord. In this case, my lord, defect number 1 is a concern, my lord. Respondent number 5 to 8 are the disease in that. Hence, proper step for the substitution may be taken, my lord. In this case, my lord, earlier file, my lord, code below, my lord, substitution petition, my lord. But name is a non-delete, my lord.
I don't know. You file an application, appropriate application as per law.
Or
4 weeks time to remove the defect.
or 2 defects, my lord. डिफेक्ट नंबर 4 वाला सीसी ऑफ डिग्री वाला टाइटल हम इसको टाइप कॉपी फाइल कर चुके हैं हुजूर और डिफेक्ट नंबर 5 में लॉर्ड एक्चुअली ये टाइपिंग एरर है हुजूर नीचे कोड का देखा जाए डिफेक्ट नंबर 5 का डेट ऑफ सीसी ऑफ जजमेंट डेट टाइटल सो नंबर 18 दो पेज नंबर 1 डिफर फ्रॉम द लास्ट पेज ऑफ 18 माय लॉर्ड ऑल पेज नंबर 1 है डेटेड 18th डे ऑफ अगस्त 2010 माय लॉर्ड और ये 2011 का सिग्नेचर है हुजूर
The certified copy of the judgment, the decree.
Judgment, my lord.
The judgment be sent out to the court below for correction in terms of the office note, office defects as pointed out, full stop. The other defects should be removed within, the remaining defects should be removed within 4 weeks.
Actually 2011 ही होगा हुजूर मैं
That has to go for correction, Mr. Sinha.
चलिए oblige my lord ये सब्स्टिट्यूशन यहाँ फाइल करेंगे हुजूर
I don't know. I'm not here to advise. Yes.
Serial number 6, second appeal 116 of 18, Mr. Nehru Mato, Mr. Sujendra Prasad. One defect, could be short of
3 weeks to remove the defect, no one appears.
Your Lordship, serial number 5 was not called.
Serial number 5.
Serial number 5, second appeal 106 of 18, Mr. Anup Kumar Mehta, Mr. Nikhil Kumar Mehta, Mr. Amit Kumar Sinha.
Your Lordship, I am GC to Mr. Anup Kumar Mehta. In this case, also the records, the defect number 7 and 9, for correction of this, it has to be sent to lower court also.
The judgment degree be sent to the court below for making necessary corrections in terms of the office notes. First up, the rest of the defect should be removed within 4 weeks.
Obliged, Your Lordship.
Serial number 7, second appeal 133 of 18, Mr. E.G.A. Gandhan.
My lord, in this case, my lord, I am appearing. In my noting, my lord, perhaps all the defects have been removed, 7 except 5. That is a confusion. I am not sure whether it has been removed or not. बहुत सारे का इसको रिमूव कर चुके हैं.
Yes. What are the defects which remains?
The nomenclature of case may be corrected by amending title appeal as civil appeal at first page of index, synopsis, memo, and agreed portion. That I am not sure whether it has been.
The judgment will be sent to the court below for necessary correction in view of the first up, the rest of the defects to be removed within 4 weeks.
Obliged, my lord. Sorry, my lord, one thing. So far as defect that is sent to the load, it is defect number 4 that was sent.
That was sent.
That, yes, defect number 4 that was sent.
Still, they are showing the defects. Let's see. Defect 3 and 5 partly removed. उसको काटिए. Defects to be removed. The remaining defects to be removed within 4 weeks.
Right.
Serial number 8, second appeal 143 of 18, Mr. Rahul Kumar Gupta, Mr. Avinash Anand.
Lordship, appearing for serial number 8.
Yes.
We're praying for time for additional defects if there are any.
4 weeks. 4 weeks to remove the defect.
Obliged.
Serial number 7, Your Lordship. IE has been filed for withdrawal of the case.
Serial number 7. Serial number 7 called not called out. Serial number 7.
No, Lordship. I'm sorry. Serial number 17. I'm sorry. Lordship. I'm sorry.
Yes.
Serial number 9, first appeal 3 of 21, Mr. Sandesh Haji for the appellant.
May I please, Your Lordship?
Yes.
Your Lordship, I'm praying for 2 weeks time, Your Lordship, for removing of defects.
3 weeks to remove the defect.
Much obliged, Your Lordship.
Serial number 10, first appeal 5 of 21, Mr. Piyush Krishna Chaudhary, Mr. Anand Kumar Sinha.
Yes. 4 weeks. 4 weeks to remove the defects.
मिलट सीरियल 6 पार हो गया हुजूर, सीरियल 6 में नहीं ज्वाइन हो पाया था।
Next.
Under the heading for orders.
No, any passover?
No.
Order has been passed. You just remove the defects within 4 weeks, most probably. 3 weeks. 3 weeks. 3 weeks to remove the defects.
कोर्ट फी का डिफेक्ट दिए हुजूर, कल दे दिए।
कल जमा कर दिए हैं?
कोर्ट फी जमा कर दिए हैं कल मिलोट।
लिखिए 6, write down 6. Mr. Mahato submits that he has already deposited the deficit court fee for sub office to check and proceed.
If any other defects मिलोट, I will remove the within मिलोट 2 weeks.
The other defect, or है कुछ defect there? Is there any other defects? No, only court fee defects.
Yes मिलोट।
Next is orders.
Under the heading for orders, serial number 11, first appeal for the appellant, Mr. Vikas Kishore Prasad, Mr. P.C. Roy, for the respondent.
सीरियल नंबर 10 में 4 वीक डिफेक्ट।
Who is appearing? Serial number?
10.
Passover. We are in 11. 10, 4 week has been granted to you. Yes. Passover.
Serial number 12, first appeal 174 of 15, Mr. Amit Kumar Das, Mr. Arvind Kumar, Mr. K.K. Bhatt, Ms. Jyoti Nair, for the appellant, Mr. Sachin Kumar, for the respondent.
Lordship, in this case, I appeal for on behalf of the appellant, Your Lordship. There's an IA for condonation of delay of 8 days, Your Lordship. IA number 1508 of 2016, Your Lordship.
Which was the respondent states. What do you have to say?
Your Lordship, I am supporting the appellant, Your Lordship, in this case.
You're supporting the
Appellant, Your Lordship.
Who is the respondent? In respondent.
Lordship, there are private respondents. Land
Private
acquisition.
respondent is also there. Your Lordship.
Issue notice to respondent number 1, 2, and 3. Registered ordinary 1 week. Requisites to be filed within 2 weeks, both on the limitation and in the main matter.
Your Lordship, my appearance may be.
It's a serious slip, appearance slip.
Serial number 13, first appeal 201 of 15, Mr. Naval Kishore Prasad, Mr. Abhishek Piyush, Mr. Alak Kumar,
In this case, Your Lordship, on last occasion, time was given for filing counter affidavit, my lord, but due to corona.
Counter what counter? Counter in what?
Counter in IA, Your Lordship, for limitation, Your Lordship.
Limitation. Limitation was filed when?
Order dated 30th.
8/9/2017, Lordship, limitation has been filed.
How many days delay?
209 days, Lordship.
209 days.
Yes, Lordship.
That's it.
Reason
I have reason, Lordship, in para 3, Lordship, I have given the reason. I have not properly examined the value of property, so that, Lordship, I have filed the petition in learned lower court, Lordship. When I come to know the property more than 31 lakhs, then we withdraw that petition and file it.
Where is that? Where is that?
Lordship, in para 3 of my IA, Lordship.
7472.
Yes, Lordship, 7472. Page number 5, para 3, Lordship.
7472. Yes, Mr. Srinivas, right?
Your Lordship, limitation may be condoned, Your Lordship.
Heard the counsel for the appellant, heard the counsel appearing on behalf of the respondent. IA number so and so. There's a 209 days in filing the first appeal. In the application file praying to condone the delay, it has been mentioned that after the judgment was passed in the title suit number 11 of 2009, the appellant, due to inadvertence, filed the first appeal before the principal district judge Kodarma. Full stop. Thereafter, on scrutiny, it was found that the valuation of the property, suit valuation was 31 lakhs. And thus the pecuniary jurisdiction, thus the district principal district judge has got no pecuniary jurisdiction to hear the appeal. Full stop. The appeal was withdrawn on 23/7/2015. Full stop. An application was filed on 23/7/2015 to withdraw the appeal. Full stop. The said application was disposed on 1/9/2005. Full stop. After disposal of the said application, the certified copies of the other documents were obtained, and thereafter this appeal was filed, which resulted in 209 days. Full stop. Next para. After hearing the counsel for the appellant, I find that sufficient ground has been shown to condone the delay. Delay condoned. I allowed.
Deeply obliged, Your Lordship.
Lords, one serial number 11, Lords, I could not appear. It just passed.
Please don't interfere in the proceedings. Take information from the court master. And if the case is passed over, it will be called out in usual course, where the passover cases are called out. I will not stop a proceeding to take up your case. Yes, next.
Serial number 14 with serial number 15. Second of Mr. Kishore, Mr. Sanjay Kumar Pandey for appellant in first case. Mr. Kishore, Mr. Sanjay Kumar Pandey. Number 2 for appellant in second case. Mr. Sharendra Kumar Tiwari for respondent in both cases. Mr. Rukmani Kumari for respondent in second case.
My lords, in this case, I am appearing on behalf of appellant, my lords. In this case, I have filed 2 interlocutory applications, my lords. One for substitution and other for condemning of delay, my lords. Substitution petition.
Just a minute.
Hajur.
Why 2 appeals?
My lords, one against preliminary decree and other against final decree, my lords, arising from this, my lords. In this case, my lords, I had filed 2 interlocutory applications, my lords. One for substitution of respondent 2 and 26, my lords, and other for condemning of delay, my lords. IA against substitution, my lords, has been listed, my lords, and other petition is defective, my lords. Though today it has been numbered, my lords. So it may be taken up in the next week, my lords. A date may be fixed, my lords.
Next week.
Defect has been removed, my lords.
The counsel for the appellant prays to list this case next week. List this case next week under the same heading.
Lordship, in both cases, petitioner be directed to serve the memo of appeal. Lord.
Serve the memo to the respondent. Yes, he's saying this.
ये तो अपने
Copies.
Serial number 16, second appeal 419 of 16, Mr. Sumit Gadodia, Mr. Shailendra Kumar Singh, Mr. Akshay Kumar Mahto, for the appellant, Mr. Bhaiya Vishnu Kumar, Mr. Abhishek Kumar, Mr. Ranjit Kumar, for the respondents.
Lordship, I am appealing for the appellant, Lord.
Yes.
Lordship, in this matter, we have filed two interlocutory applications, one for the substitution of respondent number 3, my lord. IA number 8096 of 2019.
8096.
Yes, Lordship.
$8096. Yes.
Lordship, in this praying for substitution of respondent number 3, my lord, and the legal heads, the name of the legal heads are mentioned in para 11 of the IA, Lordship.
You have settled the dispute amicably.
Yes, Your Lordship. Yes, Your Lordship. But because the respondent number 3 has not been substituted, my lord, there is a problem with the parties in agreeing to a final settlement of the dispute, Lordship.
He died in the year 2018.
2018, Lordship.
Your substitution application is dated?
Lordship, we have filed the substitution application on 26th of August 2019, my lord.
So it is not within time?
Lordship, there is a delay of 149 days, my lord. And
What
for
is
that
the
purpose, we have
condemnation?
second IA, Lordship, 8097, we have filed for that purpose, my lord, for condemnation of delay of 149 days.
Yes, who is appearing? Switch on. Vishwajit, switch on. Switch on the microphone.
Extremely sorry, my lord.
Yes.
I am appearing on behalf of the respondents, my lord. Since the parties have amicably settled their dispute.
For the parties. First up, this application has been filed to substitute the deceased respondent number 3 who died on 28/12/2018. First up. It has been submitted that this cause of action survives and devolves upon
Surviving respondent
son of the deceased, namely Saddam Hussein and Jahangir Ansari. Paragraph 11 of the IA. Full stop. Prayer has also been made to set aside the abatement, if any. Full stop. IA number, take both the IAs together, this IA and IA number 8097 of 19. Full stop. An IA has been also filed to condone the delay in filing the application for substitution. Full stop. The opposite party has got no objection if these petitions are allowed. The respondents have got no objection. Full stop. Considering the submission and the fact that cause of action survives, both the IAs allowed, substituted, full stop. Delay condoned, be substituted, necessary corrections be made in the memo of appeal within 3 weeks. IA disposed of. Yes.
Okay, Lordship.
Yes.
Serial number 17, second appeal 466 of 16.
Lordship, IA has been filed for withdrawal of the main application, second appeal 466 of 2016, Lordship.
This 17.
Yes, Lordship.
You want to
Yes,
withdraw?
Lordship, serial number 17.
What is IA? The IA number 46, IA number 2878 of 2020. Okay, so this IA has been filed, praying therein to allow the appellant to withdraw this second appeal. So it has been submitted to the appellant, who is the tenant, has already vacated the house and thus doesn't want to pursue the second appeal. Full stop. Next para. Considering this submission made in the statement made in the IA, this IA is allowed. Full stop. Next. IA, SA 466 of 16 will here. Considering the fact that the IA has already been, IA number so and so praying for withdrawal has already been allowed, this appeal also stands dismissed as withdrawn.
Obliged.
Serial number 18, second appeal 478 of 16. Mr. M. Sharma, Mr. Suraj Kumar, Mr. Sailendra Bhushan, Mr. Prakash Kumar for the appellant.
My Lord, in this case, I am for the appellant, my Lord. My Lord, there are two interlocutory applications has been filed for the same trial, my Lord, for a stay of the execution proceeding, my Lord. So I may be permitted to withdraw the first interlocutory application number 4103, 2020, my Lord.
Which one do you want to withdraw?
IA number 4103, 2020. Due to, my Lord, inadvertence to IA has been filed, my Lord.
IA number
03, 2020.
4103 of 2020, right? The counsel for the appellant seeks permission to withdraw the same. Where allowed, the IA is dismissed as withdrawn. Yes, where is the other one?
Second one is for a stay of the proceeding of execution case number, my Lord. My Lord, during pendency of this appeal, my Lord, the defendant have filed the execution proceeding, my Lord. My Lord, my Lord, facts of the case is that, my Lord.
Just a minute. Just a minute. This is a second appeal.
Yes, my Lord.
So the second appeal will be heard. Place this case under the hearing for hearing under Order 41, Rule 11 of the CPC. It has not been admitted.
Yes, my Lord, not there. Yes.
It has not been admitted.
Yes, my Lord. Yes. Let it be heard, my Lord. Any date may be fixed, my Lord.
Yes, it will come in usual course.
Obliged.
May I have your kind attention, please? There is some technical issue at our end. It will be resumed within 5 minutes. Thank you.
कोर्ट मास्टर साहब क्या मैसेज दिए?
Am I audible? Am I audible?
Yes, Your Lordship.
My lord.
Yes, Your Lordship.
But I can't see any one of you.
Yes, my lord is audible, my lord.
Yes. Yes.
Serial number 19, first appeal 208 of 18, Mr. Suraj Singh, Mr. Indrajit Sinha, Mr. Vikas Sinha, Mr. Vipul Kotar, Mr. Ajay Kumar Shah for the appellant, Mr. Vikas Kishore Prasad, and Mr. Ramchandra Sahu for the respondent.
Your Lordship, in this matter, my lord, I am appearing on behalf of appellant, my lord.
Yes.
Your Lordship, in this matter, my lord, we have filed an IA for substitution of the respondent number 1, 8, 9, 10, and 16, my lord. Your Lordship.
1, 8, number?
IA number, my lord. 6031, my lord.
6031.
Of 2021.
1, 8, 9, 10, 16. When did they die? When did they die?
Yes, Your Lordship. Your Lordship, from the service report, my lord, it has been informed to us, my lord, that respondent number 1896, 1, 8, 9, 10, and 16 has died, my lord.
So when did they die? I'm asking you.
Your Lordship,
Find out that. You have to find out because then there's a question of limitation also.
Yes, Your Lordship.
You have made a prayer. The IA number so and so. Counsel for the petitioner submits that respondent number 1, 8, 9, 10, 6 died during the pendency of this appeal. He further submits that they could only come to know, the appellant here, corporate, could only come to know about the death once the notices, the service report of the notices was returned unserved with the endorsement that they are dead. Because it submits that the date of death is not within the knowledge of the appellant and they couldn't ascertain the same, even in spite of their best efforts. First up, it has been prayed that the delay be condoned and the abatement, if any, be set aside, and the respondent number 1, 8, 9, 10, 16 be substituted by the legal heirs, namely so and so, so and so. Next paragraph. It is also submitted the cause of action survives. First of, after going through the petition, I find that 1, 8, 9, 10, respondent number 1, 8, 9, 10, 16 is dead during the pendency of this appeal. The legal heir of respondent number 1 is so and so, 2 is so and so, 8 is so and so. Go through that. Also, further, I find that the cause of action survives. Also, this I is just allowed. The name of so and so be struck off from the cause title and be replaced by and be substituted by the legal heirs whose details have been mentioned in paragraph so and so of the idea. If I just as allowed, necessary corrections to be carried out within 3 weeks by reading the cause title by the counsel for the appellant.
Obligement. My lord, one thing, my lord, I may point out. Your Lordship, from the order dated 17 February 2021, my lord, it appears that respondent number 1, 8, 9, 10, 16, and 20 and 21 also died, my lord, but we have filed substitution only for 1, 8, 9, 10, and 16. Your Lordship,
from 9, 10, and 16 also 20, 21, when you will file an I will listen to it.
Yes, Your Lordship, further time may be given to file
No,
this.
I'm not granting you any time. If you file any, we will be considered. We will be considering that. Yes, next.
Serial number 20, first appeal 211 of 18, Mr. Indrajit Sinha, Mr. Vikas Sinha, Mr. Vipul Kotar, Mr. Harshvardhan for the appellant, Mr. PC Roy, Mr. Ramchandra Sahu for the respondent.
Your
21.
Lordship,
Yes.
Your Lordship, I am appearing on behalf of the appellant, my lord. In this matter, my lord, on last respondent number 1, 6, 10, and 11 has been substituted, my lord, and so far respondent number 14 to 16, my lord, we were allowed to file an
Paper publication.
paper publication, my lord. We have filed an IA supplementary affidavit, my lord, annexing the your lordship paper page number 6, my lord, of the supplementary affidavit, my lord. We have done the paper publication, my lord.
Where is it? IA supplementary affidavit. But where is the newspaper?
Your lordship,
Which newspaper it was published?
your lordship, in the Prabhat Khabar, my lord, page 6 of the supplementary affidavit, my lord.
Another one?
Another one. Prabhat Khabar.
14 and 15.
Yes, sir.
14 and 15. Where is the original paper?
Your lordship, it is. We have filed the photocopy, my lord.
Yeah, you have to file the original paper also.
Your lordship, it was downloaded by the.
No. The original newspapers, copy of the original newspapers, which published the notice pursuant to the order of this court upon respondent number 14 and 15 be placed on records along with an affidavit.
My lord.
Serial number 21, first appeal 221 of 18. Mr. Suraj Singh, Mr. Nitin Sinha, Mr. Vivas Sinha, Mr. Harshvardhan, Mr. Abhay Kumar.
Your lordship, on last occasion, my lord, fresh notices has been issued upon the respondent number 4 to 8, my lord.
Yes. Yeah. Office report suggests that necessary correction in the cost title has not been carried out. The counsel is directed to, counsel for the appellant is directed to make necessary corrections in terms of order dated 23/9/2021. Full stop. Fresh notice on correct and present address upon respondent number 4A, 5A, 5B, 6A, and 6B. Let's stop next para. It has been reported that respondent number 1 and 2 is dead. Within 5A, 5B, you have written 6B. Also to respondent number 9, 10, 11. Await for the service report of respondent number 1, 2, and 3.
Obliged, my lord.
Serial number 22. Mr. S. Mani, Mr. Sumit Kumar Mato for the appellant, Mr. P.C. Roy for the respondent.
Yes.
There is an IE for condoning the delay of 469.
Who is appearing? Who is appearing? Switch on, Mr. Bhumik, switch on.
Yes, Lordship. Sorry, Lordship. There is a delay of 4698 days, Lordship. In similar matter, coordinate bench of this court has condoned the delay, Lordship. In similar circumstances, we have filed one supplementary affidavit yesterday. We have sent it by mail, Lordship.
Similar circumstances. How many years?
4698 days delay, Lordship. 11 years. 11 years, 3 months delay, Lordship.
What is it?
Lordship, we have stated in paragraph 3-4. May I read it, Lordship?
Yes.
Para 4, Lordship. That against the said analogous judgment and award, a first appeal being FA number such and such arising out of LA case number 62 of 89 has been preferred before this honorable court on 13/4/2000 and in terms of order dated 21/6/2007 passed by this honorable court. Separate award with respect to particular LA case was ordered to be prepared by the learned court below, and consequently having prepared separate award case wise, learned court below was pleased to send back the records of the case before this honorable para 5, Lordship. That inadvertently, in view of the stamp report, the name of the petitioner number 1 and 2 from the records of FA number 48 of 2007 have been struck down, and prayer was confined to one LA case number 62 of 89 filed by the appellant Arunjay Kumar Singh. However, no separate memo of appeal against the said judgment and order in other analogous cases could be preferred, which has necessitated filing of the present memo of appeal. Then Lordship, para 7, that a miscellaneous case number 15 of 2001 was filed in NA case number 3 of 89 under order 9 rule 4 of the CPC for restoration of LA case number 3 of 89, which was dismissed in default on 11/2/2000, which was subsequently allowed in terms of order dated 1/10/2004, and consequently LA case number 3 of 89 stood restored to its original file. Then para 8, Lordship, that it is matter of the after death of father of the petitioner, namely Jwala Prasad Singh, on 30/6/2004, an application for substitution of legal heirs and legal representative Jwala Prasad Singh in miscellaneous case number 15 was filed, which in turn stood allowed in terms of order dated 3/9/2004, wherein the name of the petitioner Jwala was expunged and in his place name of petitioner substituted. However, inadvertently, neither the name of said Jwala Prasad in LA case number 3 of 89 could be expunged, nor the names of the petitioners could be substituted, resulting the judgment and award passed was prepared in the name of the deceased Jwala Prasad, which may be corrected in the ends of it. Then Lordship, finally para 12, that a petitioner inquired about the matter from the information center of the High Court on 4/9/18, whereby they were informed that no separate appeal on their behalf has been preferred except AFN number such and such in LA case number such and such.
The judgment 2006.
And we have filed one supplementary affidavit, Lordship. In so many words, we did not allege against, wrote against the deed and advocate, Lordship, but there is judgment.
There is nothing.
Coordinate bench has condoned the delay in similar circumstances, Lordship.
What are the grounds? Pardon, Lordship? What happened after?
Then I will file one supplementary affidavit, Lordship.
Serial number 23, first appeal 500 of 18, Mr. Rajendra Prasad Gupta, Mr. Sambit Nayak for the appellant, Mr. Manoj Prasad, Mr. Vinod Kumar for the respondent.
His Lordship, I am appearing on behalf of the respondent, number 528.
Who is for the appellant?
Just Sambit Nayak informed me that उनको स्टैंड लग गया है, वो हार्ट अटैक उनको हो गया है, तो स्टैंड लगा हुआ है, वीकनेस के कारण वो बोले हम नहीं कर पाएंगे, आप ही बोल दीजिएगा कोर्ट को.
The request of the learned counsel for the appellant. This case is adjourned for 4 weeks.
Yes, oblige my lord.
Serial number 24, second appeal 150 of 19, Mr. Jitendra Kumar Pasari for the appellant, Mr. P.S. 40 for the respondent.
Yes, my lord. I am for the appellant, my lord, in this case, my lord. I have filed one, my lord, IA number 1325 of 2022, my lord. IA number 1325 of 2022, my lord, by which the learned executing court has vacated the stay on the ground of judgment of the Supreme Court of Asian resurfacing, my lord, of road agency, my lord, which is at page number, my lord, 12 of that IA, my lord.
Where is this stay order?
Stay order is, my lord, on 27th to 2020, my lord. That is, my lord, order number 3. Order number 3, my lord, may we see, dated 27th of the February 2020.
Who is appearing? For the other side.
I am appearing, Lordships.
Yes.
Mr. PSP has to assist the Lordship, but he is now in court number 1, my lords, on his legs, Lordships.
Call him.
Pass over, my lords.
Call him immediately. LCR hai ya? You are the tenant, Mr. Pasari?
Yes, my lord, yes.
What is your ground?
Appellant is the tenant, my lord.
What is your ground?
Ground is, my lord, the perversity, my lord. The learned appellate court and the trial court has not discussed the evidences of the appellant, my lord, regarding the payment of the rent. The defense witnesses was not discussed in the judgment, my lord, which was categorically deposed by the defendants that they paid the rent to the respondent here in, my lord, but rent issued was not issued by him, my lord. That part of the evidence was not discussed at all by the learned trial court and the learned appeal court. So the ground of the perversity is there in this appeal, my lord.
Pass over, let Mr. Pati come.
Hello, the
You
next
are-
date is,
You are in occupation of that.
yes, my lord, yes.
Okay.
Yes. The next date has been fixed by the learned executing court on the 2nd of the March, my lord.
Okay, let him come.
Yes, my lord.
Serial number 25, first appeal 87 of 20,
Your Lordship. Your Lordship, in this case, I am appearing on behalf of the appellant, Your Lordship. One IA number 6995 of 2021 for stay of the execution, case number 1 of 2021 has been filed, Your Lordship.
I filed a rejoinder
this
to it, Your Lordship.
may I permitted some? Yes, Your Lordship, it has been admitted by the order dated 18/8/2021.
The land acquisition case.
Yes, Your Lordship. The fact of the case is that, Your Lordship, the petitioner is the respondent is claiming the said land on the basis of the documents that it is a transferable land, so the amount of compensation should be enhanced. But it is the fact, Your Lordship, in the Devgar circle, dishonestly and fraudulently converted the nature of the land from non-transferable to the transferable land and were sold and made an attempt to sell to different persons on the basis of no objection certificate, for which the CBI inquiry was conducted. Your Lordship, FIR was registered by RC number 15A/2012 D and dated 96/2012, Your Lordship, in which the charge sheet has been submitted against the then sub registrar circle officers, Your Lordship. So kindly allow me to bring on this on record, Your Lordship.
Your Lordship, all
They are
the
praying
facts
for
were
the
not
enhanced.
taken before the learned court below, Your Lordship. They are only delaying the matter, Your Lordship. They have taken over the possession of the land, Your Lordship. They are using it, but they are not making the payment, Your Lordship.
Your Lordship, we have previously.
She's hand to mouth, you know.
May I submit, Your Lordship? Previously, it was calculated on the basis of non-transferable land, Your Lordship. Later on, the objection was made by the answering respondent that it is a transferable land by producing the sale deeds, Your Lordship, which are under the matter of investigation in the CBI inquiry, Your Lordship. Kindly see the FIR, Your Lordship, which I have there, Your Lordship. Alleged instance of non-transferable land sold to different persons by making transferable by way of substituting false and fake record in revenue record of Devgar Dumka and the village Mandari Chak PS 256 is also under the investigation of that area, that CBI inquiry, Your Lordship. That's why I'm praying, Your Lordship, kindly allow me to bring it on record, Your Lordship. Reason thereby I'm praying for the stay of the execution.
Just tell me one thing.
Yes, Your Lordship.
As per you, what is the amount the respondents are entitled to receive?
Previously, it was calculated, Your Lordship. It is at page 22, Your Lordship.
Yes.
Award number 9 years, that is 96,335.
Page?
And page 22 of my appeal, Your Lordship.
22.
Yes, sir. Serial number 9, क्रमांक संख्या, that is 9. 3.650 acre, Srimati Asa Jha, 96,000. Yes, sir.
22, yes.
Yes, yes, yes. क्रमांक संख्या 9, Your Lordship. After 8, 9, 3.650 decimals. कुल मुआवजा की राशि 96,335. This was calculated on the basis of the non-transferable land, Your Lordship. Srimati Asa Jha.
Where is it? Serial number 16.
And 16 also, Your Lordship. That is for the building construction. The makan ke liye. This has been calculated.
Now how much?
Now, Your Lordship, it has been in view of the impugned order, Your Lordship, it has been enhanced from kindly see page 49, Your Lordship.
Yes.
The order impugned. Order. Yes, Your Lordship. 1 crore for the land and 3 crore 14,14,350 for the construction over there.
Yes.
And all these are the basis of the claim. From they are saying that this is a transferable land and they got this land from the sale deed, Your Lordship.
Just a minute.
Yes, Your Lordship.
Earlier, it was 92 lakhs.
Yes, Your Lordship.
92 lakhs 53,000.
On the basis of non-transferable land, it was calculated.
Just a minute. 92 lakhs 53. Where is award number 9?
Sorry, Your Lordship.
Award number 9 is 96,335.
Yes, Your Lordship. That
And
is
award number?
16.
Award number 16 is 92. So for 92, they have given you 3 crores.
Sorry, Your Lordship. आवाज clear. So I'm just praying, Your Lordship, kindly post this matter after 2 weeks. Your Lordship. In the meantime, I bring on record that FIR, Your Lordship, in which the charge sheet has been submitted, Your Lordship, that will clear the picture of this case, Your Lordship. Because, Your Lordship, in that RC case, Your Lordship, alleged illegal acquisition of aggregate of 1.40 acre of land, while LA case number, Jamabandi not mentioned, and thereafter sale and transfer of non-transferable land of area 1.10 acre of Dag Sankhya 155 and sale and transfer of non-transferable land of area so and so in Moja Madarchirik PS 256 under Devghar Circle. As per related survey, Khatyan, the above mentioned transferable sold land are of nature which is non-transferable, and they are claiming on the basis of the transferable land, Your Lordship. This is the fact in this case. And this has come during the pendency of this first appeal, Your Lordship, to the knowledge of the State Council. And so that they have also provided the copy, Your Lordship. So that's why I'm praying, Your Lordship. This has been provided. क्योंकि ट्रांसफरेबल लैंड होके बहुत ज्यादा इनहेंस हो रहा है, जो कि गलत है, ये आया है इसमें.
On the request of the learned counsel for the appellant, let this case after 2 weeks.
May I submit one thing, Your Lordship?
Yes.
This is a Basauri land, Your Lordship, and the documents submitted by the State Council before the court below, Your Lordship. I have brought it on record by way of my caveat, Your Lordship. The parcha would go to show that it is a Basauri land. The written statements filed by the state, Your Lordship, would go to show that it is a Basauri land, Your Lordship. And now they are making out a completely new case, Your Lordship. If they can show it from the award itself, Your Lordship, that any CBI MAT case was pending against the particular land, Your Lordship. They are generally bringing out record. They want to bring it on record. The general.
I will not allow, Mr. Ram. I will not allow to file additional documents over here, which was not there in the court below. I will not allow this.
Your Lordship, the Basauri land, which is my senior friend.
Court for?
Yes, Your Lordship. Yes, Your.
Law court records is there in the.
Yes, Your Lordship, it has come.
It was go.
Now, the amount.
Your Lordship, what I am submit. Yes, sir.
Just tell me one thing. Now, if this award is satisfied, the amount is paid to you. Ultimately, if this amount is modified and this court finds that you have to refund, how will you refund this amount?
Your Lordship, it may be subject to any condition. Your Lordship, my client, actually what has happened, Your Lordship, it was a shopping complex. So my client had taken a lot of loan on it, Your Lordship. Now, because of non-payment of this loan amount, Your Lordship, she is facing other difficulties, Your Lordship. So once the amount is paid, Your Lordship, she will repay the loan, Your Lordship. So any condition may be imposed, Your Lordship. Because record, Your Lordship, the parcha produced by the state.
I'm not on merits now. Question is that how will you.
May be imposed,
Your Lordship, state authorities who have given, Your Lordship, against them, Your Lordship, the charge sheet has been submitted. Your Lordship, they have mentioned it as a Basauri land and started the transfer and sale of the land, Your Lordship. Reason thereby this dispute arises, Your Lordship. And this is the part of the investigation in the CBI case. This is the fact of the case. The then circle officer, registrar, Karamchari, all are been made accused therein, Your Lordship. The state authorities are the accused persons therein.
You ask your client, Mrs. Kumar.
Yes, Your Lordship.
Ultimately, the appeal is allowed or this award is modified. And if you take this 5 crores, how much? It is huge. 3144, 8 crores now. 8 crores. How will you refund the same? How will you refund the same?
Your Lordship, I have this in specific instruction, Your Lordship, that my undertaking may be noted. My client's husband is here, Your Lordship. He will refund the amount, Your Lordship. Any condition may be imposed, Your Lordship. Any condition. Yeah, 50% de de, Hujur. 50% de de, subject to condition. Any condition, Your Lordship.
Bank guarantee?
I
Bank guarantee, seek instruction.
Your Lordship is ready to mortgage his property subject to this amount. I'll give the details of the property, Your Lordship, which can be.
An affidavit will be filed by the respondents intimating this court that in the event, if in the event the appeal is allowed and the appellant are directed to refund, the respondents are directed to refund the amount of compensation, in what manner and how they will refund the same.
Let the matter come after 2 weeks, Your Lordship, or next week. I'll find it.
After 2 weeks, Your Lordship.
If the appellant wants to mortgage any of the property, the properties, details of the properties along with the valuation as current valuation by a government valuer should, and whether those properties are free from encumbrances will also be mentioned.
Yes. Obliged, Your Lordship. If a date could be fixed after 2 weeks, Your
After 2
Lordship.
weeks.
Yes, Your Lordship, in the meantime, execution maybe.
Okay.
Execution proceeding may be stayed.
No, not now.
Okay, Your Lordship. So we can file, Your Lordship, this RC case, Your Lordship, or not?
No. Under what provision of law? This will be an additional evidence.
Yes, Your Lordship.
Yes.
Under the heading for admission, serial number 26, first appeal 123 of 19, Mr. Ajit Kumar Das, Mr. Kumar Basant Narayan.
May I please, Your Lordship?
Yes.
Your Lordship, this appeal has been preferred against the judgment dated 31/8/2018, Your Lordship, whereby the learned tribunal has allowed the claim for enhancement of compensation and enhanced the compensation at the rate of rupees 60,000 per acre, Your Lordship. Lordship, the
From
fact
what was the earlier rate?
Matter that
What was the award?
The land was acquired wide notification.
Because this appeal
Beg your
will be
pardon,
heard.
Your Lordship.
Call for the lower court records, issue notice. Both process requisites for weeks.
Right, Lordship.
Serial number 27, first appeal 203 of 19, Mr. Akshay Kumar Moto, Mr. K.C. Moto, Court of Appeal, Mr. Naveen Kumar, Mr. Praveen Aghori, Court of Respondent.
My lord, I am appearing with this case on behalf of the appellant. My lord, appellant has submitted the judgment dated 13 to 19 and decree dated 27 to 19 passed in title suit number 30 of 2014. My lord, plaintiff has filed the appellant is the plaintiff. My lord, plaintiff has filed the title suit for grant of decree declaring right, title, and interest with confirmation of possession and for a declaration of perfection of title by way of adverse possession. Another case, my lord, ancestors of the plaintiff has come in the area in the year 1945, and they converted some land for cultivation purpose, and since then they have been in continuous cultivation possession, my lord, over the land. In the exhibit 3, my lord, that is the Khatian, my lord, it has been mentioned that plaintiffs have been in illegal possession over the land since 1968. And in the year 2013, my lord, some state employees have interfered the possession of the plaintiff. Then, my lord, title should have been filed. My lord, learned court bill has dismissed the suit on the ground, on the basis of one judgment of the Honorable Supreme Court. That is page 14, my lord, of the internal page of the judgment, page 14. That is judgment 2014 1 SCC 669 in the matter of Gurdwara Sahib versus Gram Panchayat Village Sirkhala and another, in which ratio has been decided by the Honorable Supreme Court that adverse possession is one of the defense, my lord, and plaintiff has no right to file
So
suit.
in view of the latest judgment, the position of law has changed.
Yes, yes, yes. I have sent, my lord, email address, my lord. That is the latest judgment.
Admit call for lower court records issue. Who is appearing?
AC to AC minus 1 loss, I am state.
Since this respondent has already been represented by the lawyer, no notice need be issued.
My lord, I have on file IF for status quo, my lord.
Why?
My lord, they will forcefully evicted, my lord.
Why? There is no question of forceful eviction. I cannot presume forceful eviction.
Obligement.
I pending, madam.
Yes, next.
Under the heading hearing under order 41 Rule 11 of CPC, serial number 28, second appeal 146 of 15, Mr. Vishal Kumar Tiwari, Mr. Celebrity, Mr. Atul Kumar.
May I please, Your Lordship?
Yes.
This is Lordship, the second appeal referred by the appellant, plaintiff, appellant, Lordship. A concurrent finding is there, Lordship, against me.
Where is the suit?
Yes. Pardon, Lordship?
Yes. What is your case?
Lordship, the plaintiff has preferred the suit, Lordship, the declaration of right, title, and interest of village Kirkira, district Chhatra.
Read the appellate judgment. Read the appellate judgment. Read the appellate court judgment.
Lordship. Lordship, I'm just giving a brief detail of the case thereafter, Lordship.
Yes. Yes.
Several sale deeds were there, Lordship. On that basis, Lordship, we were asking for declaration of right, title, and interest. And since we were in possession of the land, and the 3 sale deeds were, Lordship, accepted by the court, both the courts below. Only there was dispute with one sale deed that was an unregistered sale deed of 1958, Lordship. And as such, Lordship, the both the courts below have given a finding against us that the sale deed was not genuine and was false and fabricated and was created later on. That was the finding of both the courts, Lordship. Therefore, Lordship, I am just confining my argument only to that portion of the judgment, Lordship. Now, Lordship, as per the genealogy which was given by us, the case of the plaintiff was that the suit property was purchased by 2 persons, one Jitan Mia and Hasmali alias Kasmali. Now, the dispute, Lordship, is with the land possessed by Hasmali alias Kasmali. As per the case of the plaintiffs, Lordship, who are the appellant before Lordship.
No, they were. You are the plaintiff.
Yes, Lordship. As per the case of my case, Lordship.
Your case is that there were 3 sale deeds.
4 sale deeds, Lordship. Total number of sale deeds.
174, 863.
Lordship, all these sale deeds, Lordship, there is no dispute accepted by the courts below. Since, Lordship, these property come from the lineage of Jitan Mia. Therefore, Lordship, there was no dispute, and the defendants have also not claimed about these properties. Therefore, that was declared. Now, Lordship, what happened? The half of the share of the land, which fell in the share of Hasmali alias Kasmali, as per the plaintiff's, Lordship, he died issueless. And whether he died issueless or not, Lordship, that is not very much material with this case. Since, Lordship, as per the Mohammedan law, when the father is alive, Lordship, he has every right to sell the land, and he is the entire whole and sole owner of the property. The sons have, there is no co-partnership theory in the Muslim law. Therefore, Lordship, what our claim was that in the year 1958, Hasmali alias Kasmali has sold the entire property by an unregistered sale deed, which was for value of rupees 96, and therefore, Lordship, the registration was not required at the time, even today, Lordship, 96 rupees, and thereby, Lordship, we plaintiff number three got entire interest from the said sale deed. Now, Lordship, the finding of the appellate court, if Lordship comes to that, because Lordship, the court has also transversed towards the whether he was issueless or whether he was having a son or not. That was not at all required in this case. Since Lordship, our case is that the Hasmali has sold the property, though unregistered, in favor of one of the plaintiff.
Will
Now,
that unregistered deed give any right to you?
Lordship,
Will that unregistered gift deed transfer any title in your favor?
Lordship, the unregistered sale deed. It is a sale deed, Lordship. This is the.
It's a compulsorily registrable document.
It is
Transferring
less than 100 rupees, Lordship. 96 rupees. That is
96 rupees.
That is not the case, Lordship. Had it been more than 100 rupees, Lordship, it was compulsory.
Price fix was less than 100 rupees.
Lordship, 96 rupees, only 96.
Okay.
Because it was of the year 1958, Lordship. Now, Lordship, I am coming to the internal page 18 of my appellate court's judgment.
Yes.
From the third line from the top, Lordship. On perusal of the evidence, this is the Lordship, the finding of the trial court, appellate court. Internal page 18 of the
evidence. Yes.
Lordship. On perusal of the evidence, I find that item number 1 of Schedule C land was purchased by Amna Khatun by registered sale deed number such and such, dated such and such, for an area of such and such. Item number 2 was purchased by Bibi Jaibu Nisha by 3 registered sale deeds such and such, such and such, such. Now, Lordship, the item number 3, that is important.
That is the only dispute. This is the only dispute.
This is under dispute, Lordship. Item number 3 is the land purchased by Sakia for an area of 3.11 acres by way of unregistered sale deed on 8/5/1958 from Hasmali alias Kasmali Mia. The actual dispute for the land purchased by Sakina, that is for an area of 3.11 acres. The defendant respondent are claiming only this land. Therefore, there is only this dispute is there. I have already discussed the evidence related to the unregistered sale deed exhibit 13. The scribe was Manohar Lal, as stated by Ganga Prasad, PW5, who has no personal knowledge about the execution of the sale deed. I have already held that the witnesses of this deed, namely Horil, MD Ali, and Hasnani, have not been examined. Now, Lordship, I'm just putting a question, pausing for a moment here, that this sale deed is of the year 1958. Is it possible for these persons to come and give their evidence? It has also not come in the judgment or by the defendants that these persons are alive. Therefore, Lordship, this observation by the court is very much perverse to the and detrimental to my case, Lordship. No witness has been brought on record by the plaintiff to prove this deed properly. The Vendi Sakina Khatun was alive at the time of hearing of title suit number itna, but she was not. But she has not preferred to be examined in the court herself. She is the purchaser of the land and has paid the consideration amount. So she was one of the important witnesses to prove the fact, in my opinion. Hasmali and in Kasmali was illiterate, so heavy onus was on the plaintiff to prove this document properly. Now, Lordship, again, one substantial question of law would be that since, Lordship, the document is more than 30 years of old, therefore, Section 90 of the Evidence Act will come into play. On the basis of the discussions, I find that the plaintiff failed to prove this unregistered sale deed exhibit 3 properly. This is the only discussion, Lordship, how we have failed to prove the unregistered sale deed. One is that the witnesses have not been examined. Second is that somewhat right, Lordship, that since Sakina was the Parda Nashin lady, he could not come and to give his evidence, though she was the plaintiff and she was the purchaser. That could be something which can be considered by the court. But the third finding, Lordship, that since Hasmali and Kasmali was illiterate, so heavy onus was on the plaintiffs to prove the document properly. Therefore, Lordship, the court has also not considered that whether a document which is more than 30 years old, the provision of Section 90 of the Evidence Act, considering and it was also brought from the proper custody. since Sakina was in the custody, and therefore the other plaintiffs, Amna Khatun, who was deposed on behalf of all the plaintiffs being a lady lordship, and this document was produced from their custody. Therefore, section 19 lordship, if lordship pleases, I'll just place section 90 of the Evidence Act.
The Evidence Act.
Presumption as to documents 30 years old. Even the custody is proper lordship. Where any lordship got that?
Yes.
Where any document purporting to prove to be 30-year-old is produced from any custody which the court in a particular case considers proper, the court may presume that the signature of every other part of such document which purports to be the handwriting of any particular person is in that person's handwriting, and in the case of the document executed or attested, it was duly executed and attested by the person by whom it purports to be executed and attested. Explanation. Document are said to be in proper custody if they are in the place in which, under the care of this person with whom they would naturally be. Since Lordship, we were the purchaser, Sakina was the purchaser, and one of the plaintiff has produced these documents on her behalf. She has stated that she is deposing on behalf of all the plaintiffs. Therefore, the custody was also proper, naturally be. But no custody is improper if it is proved to have been a legitimate origin, or if the circumstance of the particular case are such as to render such an origin probable. This explanation applies to section 81. Lordship, now the illustrations are also there. A has been in possession of the landed property for a long time. He produces from his custody deeds relating to the land showing his titles to it. The custody is proper. Therefore, Lordship, I am covered by illustration A also.
It is only in respect of custody.
Yes, Lordship. Therefore, it is not that from somewhere else we are bringing that property or someone else has produced those documents before the court. Since the plaintiff herself has produced those documents from her custody, saying that this is the unregistered sale deed of the year 1958, and that has been marked in exhibit without any objection. Though the court has come to a finding that later on that it is false and fabricated because of these things are not there. Thereafter, Lordship. As per the settled principle of law, unregistered sale deed delivery of possession is necessary, and in my opinion, Sakina was the best person to prove this fact. Now, Lordship, from the bare perusal of my plaint and my prayer, we have only sought a declaration of about the right title and interest. We have not sought for recovery of possession. Therefore, Lordship, specific reading is there, and the cause of action was that since we had gone in a circle office for some revenue work, then there was an objection filed by one son of Hasmali alias Kasmali, which we are denying. And therefore, Lordship, that gave cause of action to us. And thereafter, Lordship, the suit was filed. Now, the other things about the lineage of Hasmali alias Kasmali has been discussed. That is not at all required in this case. Since in Mohammedan law, Lordship, being the father, he is the absolute owner. Therefore, only it was required to be discussed by the learned trial court and the appellate court whether
Registration Act, what does it say?
Lordship. Section 32 onwards, Lordship.
There is no mutation in your name.
Mutation is not there, Lordship. For that purpose, we had.
Yes.
I'm sorry, Lordship. Section 17 is there, Lordship.
Yes.
documents of which registration is compulsory. The following documents shall be registered if the property to which they relate is situated within district in which, if they have been executed or on the date after such and such, registration is such and such. The instrument of gift of immovable property, the non-testament such and such. Lordship thereafter.
Your one switch, please switch on.
I'm sorry, Lordship.
Yes.
I'm just finding, Lordship, that 100 rupees, where is that? Subclause B, Lordship. 17B, Lordship. The other non-testimony instruments which purports to operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of the value of 100 rupees and upwards. This is what, Lordship, I was indicating. Or to an immovable property. To or in the immovable property. Therefore, my submission, Lordship, to that respect.
Are your non-testamentary instrument which purports or operates to create, declare, assign limits, or extinguish, whether in present or in future, any right, title, interest, whether vested or contingent, of the value of 100 rupees and upwards, to or
in immovable property.
Immovable property.
Yes. Therefore, Lordship is very much aware that therefore earlier many unregistered sale deeds were there because they were less than 100 rupees at that time. Now it is redundant since no property is less than 100 rupees.
Question is, the court holds that you have not produced any witness in support of the document.
Lordship, what we are submitting is, since section 90 comes to my rescue.
90.
Lordship, since it is a 90-year-old document and it is not possible that the Lordship, the scribe or the witnesses will be there.
The question is, the court holds that the person in whose favor the document was executed, he was alive. He also has not.
That goes against me, Lordship. That at the moment, Lordship, right at go, Lordship, I've said, but my explanation to that is, Lordship, since, Lordship, all these plaintiffs are Muslim women, they are Parda Nashin ladies, Lordship. And therefore, one of the plaintiff has been examined, Amna Khatun, on behalf of all the plaintiffs, and she has produced all the documents.
No, is she the Sakina Khatun? Over here it is Sakina Khatun.
Sakina Khatun. Therefore, I am saying, Lordship, all three persons, Sakina Khatun got that deed, Lordship, but the plaintiffs are, other plaintiffs are also there. And she was before the court and deposed.
The deed is of the year?
1958, Lordship. 9/5/1958. 8/5/1958. And the title suit is of the year 2004, Lordship.
What about this partition suit?
Lordship, it has. I can Lordship distinguish about the partition suit. It is said that one partition suit was filed, wherein, Lordship, we have shown that the Hasmali alias Kasmali had a son, and that is no more requirement in this case to be discussed. Whether he had a son or no son, since we have pleaded he had no son, admittedly, if we are also admitting that he had a son, but father had every right being the owner of the property as per the Mohammedan law. Therefore, these questions are not to be discussed for the purpose of getting the registered, for getting decided whether the unregistered sale deed was genuine or not. Had he been a son, 1 son, 2 son, 4 sons, not required. And it has been pleaded in that partition suit that such and such person is son.
Who were the plaintiffs?
One of the person, Lordship, the husband of one of the plaintiff was also one of the plaintiff, Lordship. Abdul Jabbar, Lordship, one of the plaintiff was there. He is not the plaintiff here. His wife is
title suit?
Title suit, Lordship, of 2004. 13/2004, Lordship.
Title suit was filed by whom?
This title suit has been filed by us. The partition suit was filed by one of the plaintiffs of this title suit, Lordship.
Amna Khatun and others. Who are the others?
The others are, Lordship, from naturally from both the families, Lordship, both the branches. Since, Lordship, the property was jointly purchased by Hasmali and one Chaku Mia, Lordship, who was
who are the plaintiffs? Give me the name.
Lordship, I'm just giving you. It was purchased by Ismaili Mia.
Who are the plaintiffs?
Lordship,
the plaintiffs
of this title suit, Lordship. I'm
Yes.
giving the name, Lordship. Bibi Sakina Khatun, Amna Khatun, plaintiff number 1, Lordship. Thereafter, plaintiff number 2, Bibi Jaibun Nisha, plaintiff number 2, and Bibi Sakina Khatun, plaintiff number 3.
There was separate sale deed in respect of each.
Each, Lordship. Dispute is with, Lordship, the purchased property by Sakina Khatun, plaintiff number 3. And that court has, both the courts have observed that she has not come before the court to give her deposition. There is small dispute, Lordship, whether the sale deed, which is unregistered, can be said to be genuine or not on the findings arrived at the learned appellate court.
Genuine? Where is the finding? It is not genuine.
Lordship, it has come, Lordship, later on, just in the next page. Internal page 20, Lordship. फर्स्ट पैराग्राफ के ऊपर जो देखा जाएगा 3 लाइन 4 लाइन से सो ऑन द बेसिस ऑफ द लॉर्डशिप गॉट दैट पहला पैराग्राफ सेकंड पैराग्राफ के 4 लाइन ऊपर से सो ऑन द बेसिस ऑफ द above discussions and on the cost of repetition I must say that the unregistered registered sale deed exhibit 13 is not a valid and genuine document, rather it is false, fabricated and antedated document. This is what the finding has come. And the Sakina Khatun does not require had any right, title and position over the area of such and such. As
the court holds the document, so if both the court holds that a particular document is antedated,
that is their lordship. It has the document. It has been said by. But lordship, what is the basis to come on to that finding, lordship?
That is,
I've just lordship read the findings, which is their lordship at page 18.
It's a document which is 30 years old on the face of it.
Yes, lordship.
Now, if someone comes and says that this is an antedated document, this is a manufactured document. Now, will section 90? What will be the effect of section 90 then?
Lordship, the section 90 effect will be there. That since lordship only that objection is there, and it has to be met by the evidences which is brought on the record. What the learned court, appellate court is saying, lordship, that is my question to myself. That these persons who were the scribe and the witnesses, they have not been examined on the first hand. Secondly, lordship, to somewhat.
Okay. Now, has it come in evidence that the scribes and the witnesses are dead, so they cannot be produced?
Therefore, lordship, I'm saying, lordship, none of the parties, neither we nor them, even the defendants have not said that they are alive, that they should have come. For Sakina Khatun, it has specific cases there.
Defendant will not say. What is their defendant's written statement about this document?
They are saying that it is antedated. It has been prepared for the purpose of the suit.
So 90 will not come in your help in a manufactured document. First, we have to see whether the document is not manufactured. If the document is admitted, if the document is not manufactured, then only the signature and the contents of the document can be proved if it is 30 years old in this manner.
Unregistered document.
Itself is challenged that it is a forged fake document. Then
only one thing, lordship, I am submitting. Since it is an unregistered document, it is always open to the defendant's lordship. They can raise this plea, lordship.
Yes.
Only one thing, lordship, I am praying before lordship, without admitting the case. We don't have any hurry. Let the LCR be called for, lordship may personally peruse the exhibit 13. Had exhibit 13 lordship perusal, lordship finds by the naked eye, being the expert of the experts, Lordship, that can be rejected. We don't have any case, Lordship. Only for that purpose.
See, this is you are arguing a second appeal. Both the courts have held that this document is an antedated document.
Even Lordship, what I am submitting, what I have just submitted, Lordship, that since Lordship, the appellate courts have not said that by looking into the Exhibit 13 from the very face of it.
Not necessary. Not necessary.
Therefore, Lordship, that was my genuine question, Lordship, and genuine prayer before this court, Lordship. एक बार उसको हुजूर बुला के देख लिया जाए, खाली LCR बुलाना हुजूर कुछ तो करना नहीं है. Since Lordship, this is a case of right, and a date may fix, Lordship. Within a week it can come, Lordship.
Wait, tell me.
Lordship. It is from Chetwa, Lordship. Within a week it can come, Lordship. By 10 days it can be decided.
It's not necessary.
Because that is the only my case, that it is a genuine document, and only on the perversity of the judgment of the
if a document is genuine, how will you prove that the document is genuine? Only there is an interpolation, the document will become.
That is not the Lordship. By Lordship,
A document can be fake without interpolation also.
Yes, that can be fake, Lordship. Very purposely that can be created. No doubt about that, Lordship. Only I am submitting one thing.
Coupled with the fact that that document was not used by you at any point of time to seek mutation also. To seek mutation also.
Since Lordship, we were in possession of the property. एक ही साथ जो सारा property था, हम लोग उनसे खरीद के we were in possession of the property. When we had gone for mutation of the said property, then an objection was raised. It is not that yes,
that this property was not sold to you. Objection was raised. The 3 properties were sold, but the 4th property was not sold to you.
Yes, that is the case.
And you have inserted an unregistered deed along with a registered sale deed. Now just tell me, give me a simple question. When was the date of the earlier deeds?
I'm just giving dates. 1983, 2 dates of 10/1/1983, one of 9/11/82, and 4th of 19/2/1988.
One is 19/2.
9/11/82. 9/11/88. 19/2/88.
Okay.
10/1/83. 2 deeds of 10/1/83.
From whom you have purchased?
A purchaser is Amna. Therefore, Lordship, from one
and now these 3 registered deed was purchased from whom?
Dahiya Bibi.
Dahiya Bibi.
Lordship. But Lordship, one thing I am indicating, because these sale deeds are from the share of Ismaili Mia itself. Therefore, defendant don't have any objection. The appellate court has also observed, Lordship. Only with respect to the share of Hasmali alias Kasmali, that is only under contention, Lordship.
Hasmali is also dead.
Hasmali is dead, Lordship. He died issueless as per us, but as per the defendant's Lordship, the defendant number 7, Ishaq Mia, claims himself to be the son of Hasmali alias.
What is the finding?
The finding is that the Ishaq Mia is son, because in the partition suit we have shown that Ishaq Mia is the son.
So once you take a plea that in a particular suit that Hasmali did not die issueless, he had a son, and now you come up with a plea that he died issueless.
It is in this case, Lordship. But
for the purpose of this deed, what is your intention? Tell me.
Lordship, what I am submitting, Lordship, that since the registered sale deed, unregistered sale deed, I am again repeating, Lordship, is that it is in a Mohammedan law, if even the son is alive, the father is the absolute owner of the property.
The question is not that.
It is there, Lordship. The pleading should have been there.
The question
had a son.
That you can about your intention.
Yes, Lordship. I do understand what Lordship is about. What is poking my Lord's mind. since it has been pleaded here that he died issueless, and in partition suit we were true
You
enough.
yourself admit. You
We have
yourself admit that he did not die issueless.
Yes, 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 Lordship. That thing is there, Lordship, because that also goes against me. But since Lordship, for the in Muhammadan law, the father does not require any consent from any of the.
That I would have accepted. That is already that is the position of law.
Yes.
If you have said that no, that did not die issueless, it is the father who had sold. Even if there is the son, it has got
One
no
must
bearing. It has got no
understand
bearing.
that because of the acumen of the lawyer, sometimes clients suffer.
No. Sorry.
The pleading should have been the truth should have been there in the pleading. But since Lordship that does not have any bearing on the unregistered sale deed, therefore Lordship I am arguing such. Otherwise, Lordship I should not have argued. Only on for that purpose, Lordship, my argument is there.
Both the courts held that this document is
antedated, forged, and fabricated.
Antedated and forged.
Lordship.
Now you say on basis of X evidence, it is not forged.
Yes.
Now I have to reappreciate the evidence.
No, Lordship, not evidence, Lordship. What the appellate court has held in their finding, that since Lordship these persons have not been examined, who might have been there, might not have been.
It is also not here. You have not also stated that they are dead. They cannot be brought. Once there is a question about the deed itself, 90 will come into play when the deed is clear and there is no question, no allegation of any forged or this.
Only Lordship, one thing as just as prayed earlier also, Lordship.
Tomorrow you prepare a document selling the High Court land at 95 rupees in the year 1926 and you say that section 90 will come to play.
Lordship, only that thing I am submitting before this court. By looking into that document, Lordship will come to know whether these documents,
that means,
by bare perusal of
this, that means reappreciating the evidence. That is also
only before admitting, Lordship.
Just
before
a minute. No. That is also an evidence, reappreciating that evidence.
Lordship,
that is also the appreciation of the evidence.
Lordship may find that some
that is also
can be done by doing that.
Mr. just tell me whether it is not a reappreciation of an evidence.
It is a reappreciation of evidence, Lordship, but for the interest of justice.
Can that be done in the second appeal? Now,
Lordship,
in the second appeal, a court has appreciated an evidence. Both the courts have appreciated an evidence in a particular manner. Can a second appellate court reappreciate the evidence?
Lordship, in some of the
this is also possible.
Honorable Supreme Court in several judgments, Lordship have said sometimes in the finding of facts, also in second appeal, the Lordship can.
That is on absolutely on a different ground where it is absolutely perversity.
Therefore, I was saying, Lordship, before admitting, my prayer is intermittent, Lordship. Before admitting, Lordship can within 10 days it can come, Lordship.
No,
I could have left my argument, Lordship.
Question of law involved in this appeal. This appeal stands dismissed. The detailed order I'll dictate.
Okay.
Next.
Serial number 29. Second appeal 600. Yes, for the appellate.
May it please your lordship. My lord, this second appeal arises out of a suit for declaration of a right title interest over a piece of land along with a prayer for a permanent injunction. The case, according to the plaintiff, my lord, that the plaintiff has a land just connected to the suit land, my lord, which is being used by the plaintiff since last 45 years as a easementary rights, my lord, egress and egress purposes. Now, my lord, admittedly, the petitioner in right earnest applied for settlement of that land with the government, and upon inquiry, the offices of the circle officer, then the land reforms deputy collector, and the SDO gave a favorable report that it can be settled. It's a government land, गैर मजूरवा खास, गैर मजूरवा मालिक land.
If you want the land for only your ingress and egress,
My
where is the question of settlement in your favor?
Milord, in fact, it is just.
Why a government land be settled in your favor only for the purpose of ingress and egress?
Milord, the reports are there, Milord, that in fact.
Forget about the reports. Forget about the report. Just answer this question.
My lord.
Why a government land will be settled in your favor only for the purpose of ingress and egress?
Because that is the only.
Easement right, you have a easementary right as per law. You can use it if someone objects or obstructs your easementary right. You can file a suit.
Till date, Milord, nobody has objected.
So then, where is the question?
Settlement
in your favor. Why? Why the land will be government land will be settled in your favor?
And Milord, because that is at between the road and my land. This is the only piece
so
of.
You have easementary rights. No one is objecting to your easementary rights. Why a title?
Milord, just to avoid any future obstruction.
No, you can't acquire government land in this manner.
And Milord, this.
You can't acquire government land in this manner. Why you should only get the government land? Why not the others? Why not the others? You have no right to be settled.
Milord,
You have no right to get settled.
Apart from me, Milord, there is no. Apart from me, I have a. Apart from me, there is no other person who has interest over this piece of land.
Has the interest been sought for by the government? That yes, I want to settle this land if anyone comes for that. What is the area of the land? What is the area of the land?
15 decimal.
15 decimal is a huge land.
Yes.
So you don't need 15 decimal.
Milord, I am,
yes.
Apart from this, Milord, I am in possession of this land since last 40 years.
That is not a possession. A land being used for ingress and egress is not a possession. You have a limited right.
Apart from that, it is. Apart from that, Milord, for marriage purposes, etc., in the house, in the family, this land is being used. It is just in front of my house. It is, and the court has held.
If the land of BMP is just in front of the house, you will pray for settlement of that land in your favor.
No, it is being used by BMP, my lord.
Mr. Sai, this is a very novel way to acquire.
No. In fact, Milord, if a person prays for settlement, and the state has no use for personal use, the state doesn't require it, then it may be settled.
So it should be settled, yes. If the government has no use for a particular land, can be settled, but giving opportunity to the public at large and calling for an auction, and that is the only way.
Yes, the circle officer had issued istihar, and there was no objection.
No, there's objection for settlement in your favor. I'm
Yes.
saying in an open advertisement, if the government wants to settle, it has to be settled by open advertisement, not in this clandestine manner.
No, I don't want to say that anything apart from the law should be taken into consideration. Now, my lord, the witnesses have said, I have produced 3 witnesses. The settlement orders are there, and exhibits 5, 6, 7, and 8. They are in my favor. Khatian is in my favor. Of course, with regard to my land, then the settlement order is, yes, and the settlement order in respect of the scheduled land, exhibit 5, 6, 7, and 8. They are in my favor.
No, this scheduled land means the land which belongs to the government.
Yes.
Which you have settlement. How was that settled?
No. In fact,
there was no final settlement.
No, no final settlement. The collector says, sorry, the additional collector says that the Board of Revenue is authorized to settle the land. So far, my lord, settlement is concerned, it is done by the administrative authorities.
No. Administrative authority merely recommends.
Yes, and the Board of Revenue, my lord, is a adjudicatory authority. It's a quasi-judicial office, my lord. It is not a authority to settle or not to settle a land. It can decide rather that if a order is passed, it can decide the genuineness, it can decide the reasonableness or legality of it. My lord,
What is the point of involved?
my lord,
What is the law involved?
my lord, the point involved is, my lord, that I am there since last 40 years and more on the date of filing of the suit. So, apart from the easementary right, adverse possession.
Show me. What is the basics of adverse possession? Tell me.
I have purchased my lands.
Contiguous land.
Yes.
Now, what is the principle of adverse possession?
It should be adverse.
Hostile. You're hostile to the.
Hostile to the owner.
The real owner.
Yes.
Now, your very pleadings and your argument clearly suggests that you have never claimed your title.
So I have
your application for settlement clearly suggests this case will not come under the principle of adverse possession. If there was a principle of adverse possession, you wouldn't have filed an application praying to settle land in your favor. Is it not?
Milord, that is one of my point. But one by one, I am coming, Milord.
First point goes. The adverse possession goes. Now, what is the second point?
Then easementary right I have, Milord, and the
yes, who objects? You have an easementary right, but the easementary right, having an easementary right, that doesn't mean that you have a right to get the land settled, transferred in your name.
And then, Milord, the third in my humble submission is that on my application for settlement, the administrative authorities have reported.
Recommended and reported in your favor.
Yes, Milord.
That doesn't give you any rights.
No, that doesn't give me a right. The court could have considered.
No.
The court could have considered.
Your prayer was for declaration of your right title in interest. Did you file any application, writ application directing the respondents, praying therein to direct the respondents to take a decision on the recommendation? No.
No, my lord.
You have filed a suit for declaring your right title interest.
Yes.
When admittedly you didn't have any right title in interest, and your cake was half baked.
My lord will kindly consider what your lordship is saying, my lord. The finding is not of that on that line, my lord.
I was just going. I was just asking, just inquiring from where the right flows. Where I'm just seeing whether you have any right or not.
My lord, the court has said.
Yes.
At page.
The court has clearly said that it was a mere proposal which was not given effect to.
Yes.
And none of the land was settled in your favor. So you are there for declaration of right title interest bad because you don't have any right title interest.
The court says, my lord, at page 4 of the learned appellate court judgment.
Come to page 7 of the trial court judgment.
My lord. Trial court is mostly in my favor.
No, nothing is in your favor.
Below the trial court, below at page 7, beginning from page 6, says.
Come to issue number 3. Come to issue number 3.
Issue number 3. This below, just a minute. Let me.
The name of the settlement, but none of the opposite orders were finally were passed finally settling the suit land in favor of the plaintiff. This is an admitted fact.
Just a minute, Millard. Let me place it. After placing the issue, Millard, what
Issue
is
number,
the
issue number 3.
issue number 3 is, Millard, whether the suit is barred by law of limitation.
Yes, there is a finding to come to that. There is a finding to come to that.
Then 3 that is considered in page 7.
No. Just tell me one thing. Page 7. Just clarify this finding. The recommendation was in the year 1981.
Yes, Millard. On perusal of record.
After 81, admittedly, there was no settlement order in your favor.
No. Till date, it is not.
So 81 to 98. How many years?
No. From 1958 to 19.
No. From 81 when the recommendation was made.
My lord.
To 1990 when the suit was filed. How many years?
17 years. I cannot claim, my lord. 17.
So it's barred by limitation.
My lord. No,
limitation.
From 81, I cannot claim. I claim from the date I am in possession of that land.
What are you claiming? What are you claiming?
My lord, 1958, my mother purchased the land.
Not in dispute. That particular land is not the subject matter.
Not
purchase which you have made is not the subject matter. The subject matter is the land which you have not purchased.
My lord. So I am using that land.
Yes.
Bona fidely, as being a honest citizen, I applied for a settlement.
That means you are not the title holder. Your title is not hostile. Merely using will not give. You are not entitled for a title by way of adverse possession merely because using the same. You have to show that you are using the same as a title holder.
My lord will kindly consider this is my way of making humble submissions.
Yes.
That from 1958, my mother purchased the adjacent land, and from 1958 to 1998, till the date I filed the suit, that 40 years, my lord, I am in possession.
You are using it.
My lord?
You are using that land.
I am using the land. Nobody is objecting. It is hostile and adverse to everybody, including the owner, that is the state government. Now, Lord, 40 years have passed.
This is not a hostile title.
Then, honestly, bona fidely, being a good citizen.
Your prayer is also in your plate. Have you claimed for adverse possession? In your plate, is the word adverse possession there?
Let me see.
No, it's not there. Your prayer is only for the usury rights.
Let me see.
And your prayer is to settle the land in your favor. No one is objecting to your easementary right. And no one has taken your easementary right also.
No, till date, nobody has taken.
Then, once you make a prayer to settle your land.
Yes, there is, my lord. It's a
yes.
Prayer at these. Prayer in the para 21A, first relief is further be directed to finalize the settlement in favor of the plaintiff.
Can a prayer for settlement, title by way of settlement and title by way of adverse possession can go hand in hand? Can go together? Can be claimed?
Various type of claims can be made.
Can it be claimed? Just tell me. Can it be claimed? Can a title by way of adverse possession and a prayer for title by settlement, can it go together?
Well, it can, my lord. In my humble submission.
No, it cannot. Once you claim that you are claiming for settlement, it means you know fully well you are not the owner.
No, it is adverse. It is adverse possession.
What is the concept of adverse possession? Let me understand.
Adverse possession is that I will be claiming the land even adverse to the.
You are the title holder.
Yes,
you claim that I am the title holder.
Because the statutory period has elapsed.
You claim that you are the title holder adverse to the title of the.
Yes.
Original. Now you are not claiming title. Application for settling the land clearly shows that you are not claiming title. Adverse possession means, yes, I am claiming title over possession, knowing fully well I am the title holder. I have a belief that I am a title holder, though I may not.
Yes.
Adverse possession means I have a right belief that I am a title holder, though I may not.
My lord will kindly consider in this type of cases.
But Mr. Sai, one thing. But when I say that I am filing an application that you settle the land in my favor, then where is the belief that I am a title holder?
My lord, this is my lord, a situation that although a right has accrued on me.
Right of what?
Right
of easement. No one is taking away that. I am absolutely with you so far as ingress and egress is concerned. If someone objects your ingress and egress, you can very well say that there is no other alternative road. So this is
finding.
This is the only road. I have ingress to egress. It cannot be settled to anyone. No construction can be made. I have a right over that.
Yes.
It's only for a limited purpose, not this title. There's nothing in it. Dismissed.
My lord will kindly consider that so many reports have been given in my favor.
Absolutely, I'm absolutely with you. The report
says,
the report doesn't mean that you are entitled.
My lord, the court says that it can be settled only with Harijan. Patna High Court says that is contrary to Article 14 and 15(1).
No, it's not. All this cannot be settled.
So, my lord, in my opinion, the finding requires a consideration as a substantial question of law. That, my lord, here, my lord, the finding at internal page 4 of the appellate court judgment, and there is no evidence, no oral evidence, no documentary evidence by the state.
Why should state give an evidence? It is you the plaintiff. You have to stand your own leg.
Yes, my lord. So, my lord, here, my lord, just 4 lines from the bottom, page 4.
Yes.
Running page 9.
Yes.
It is further pleaded by the defendants, that is the state, that government land can only be settled in favor of Harijan and Adivasi. This is contrary, my lord.
Question is, even if it is hold that it can be settled in favor of a general, but
any person,
even then also the land has not been settled in your favor till date. So you have no time. Dismissed.
My lord,
item number 24, my lord.
Just Mr. Pasari. Yes, Mr. Sir. There's nothing in it.
My lord will kindly consider it, my lord.
There's nothing in it.
If I'm able to place the case before your lordship, I have every hope that my lord will consider.
You placed it. There is no point of law involved. Admittedly, you are not a title holder.
टाइटल होने से तो हम पहले उसी को प्लेस करते हैं.
है ही नहीं. And your prayer is for declaration of your right title interest. On basis of what? On basis of a proposed recommendation of settlement in your favor, which cannot be.
But my lord may kindly say that it will not be a bar by the state for the state to consider my settlement.
No. Absolutely not. Yes, Mr. Pasari.
Item number 24, my lord is called Mr. P.S. Pati, my lord.
Where is P.S. Pati?
I don't know, my.
Next week.
My lord, date is the second, my lord, in the court below.
Today's
28.
28. Yes, Mr. Pati.
That Harijan and Adivasi may go, my lord. Otherwise, I will.
That is not the issue. Also,
it will attain finality by the High Court.
That is also.
They will not settle. They will not settle.
That is for the state. State doesn't want to settle. They will not settle.
That much, my lord, may kindly say that.
No, you are not at all. You are not at all. You are not at all interested in that.
No,
Whether
only that bar may go, my lord. That,
no, that is
let us just
stay.
say one line that
No.
the finding that it can be settled.
No. Absolutely not.
Hello, he has come, my lord. Means
Yes,
the PS30.
you are evicting him. You are evicting him.
Yes, my lord, there is a yes, the execution proceeding is going on.
So Mr.
I was only playing if some date is fixed in meanwhile
Appeal
also.
has been admitted. This appeal has been admitted.
Yes.
Now just answer this. If this appeal has been admitted, since there is a substantial point of law has already been framed. Now, if this point of law is answered in his favor, this appeal will be allowed. Then, if he is dispossessed, then what will happen? Multiplicity of proceeding. Why there will be a restitution? Why there will be a multiplicity of proceeding? Balance of convenience is in his favor. The substantial as the court has framed a question of law, that means there is a case in his favor. You address this tomorrow?
Not tomorrow on the issue of
This on the IA.
IA.
On stay. Yes, tomorrow.
Your lordship may fix a date for final hearing of the second appeal itself.
Final hearing not possible. Final hearing, no, there are several cases. Why should you get preference?
Well, then in that case, he already has a stay, my lord. He was granted a stay.
The stay was granted and the stay was also granted. Now, because of the Honorable Supreme Court's judgments, now you come with a judgment, Mr. Pasari.
Yes, madam. I have.
Not that. Day before yesterday or a day before that. There's a judgment of the Supreme Court in a writ application. The stay was not granted. The Honorable Supreme Court says why the stay was not granted. Ultimately, if the stay is not granted, the case will become infructuous.
The case cannot be made infructuous.
2 or 3 days prior, the Supreme Court, Honorable Supreme
I will
Court,
send it on email, my lord. I have read that case. Yes.
in your favor, Mr. Pasari.
Yes, again, it goes in his favor.
Tomorrow. Actually,